Well, good evening, everybody. And welcome to the Anthony Connerty Memorial Lecture. I'm Stephen Hoffman. I'm the head of trainings at Six Pump Court, which was Anthony's last professional home. And we were very proud when he told us that it was the most charming place in which he'd ever worked. He helped us to develop our arbitration team, introducing, among other things, new associate members from both from this jurisdiction and from abroad. And we were delighted to have him with us for a few years at least before he was sadly taken from us. His arbitration network included the International Dispute Resolution Group, the IDR group, which he established in 2008. That group, among other things, organized conferences around the world, places as far afield as China and Turkey. When the IDR group realized that it had lost its leading light and its prime mover, its committee decided that it should be wound up, but before finally ceasing its activities, they wanted to organize this tribute to its founder and to put its remaining funds towards this lecture. And so, in conjunction with the IDR group, Six Pump Court is hosting the event. And we're very pleased to welcome this evening members of the IDR group, including my good friend and colleague James Clancy, one of our associate members, who has been instrumental in organising this evening, and he will say a few words after the formal part of the proceedings concludes. We're also very pleased indeed to welcome members of Anthony's family, his three children, Julian, Simon and Sarah, all of whom I've managed to meet, and their partners and children. Sadly, Margaret, Anthony's widow, is unable to be with us tonight, but I'm sure she is here in spirit and is giving us every possible support. Now, I want to say a few more words about Anthony's career. He was called to the bar at this inn, Inner Temple, in 1974. He'd had a first career as an accountant, and then he became interested in alternative dispute resolution and in international arbitration. He took an MA in International Comparative Business Law and a postgraduate diploma in International Commercial Arbitration at Queen Mary in Westfield College, as it then was, which is where our lecturer tonight is a professor. Anthony qualified as an accredited mediator and as a chartered arbitrator, and became involved in international commercial arbitrations of all kinds, both as counsel and as arbitrator. He was appointed to tribunals at seats and venues around the world, as far afield as New York, Lagos, and Shanghai. And he was particularly proud of his involvement with CTAC in China. Nearer to home, he got to know the International Cotton Association, based in his native Liverpool, which he was very fond. And he wrote articles, and he wrote a book commissioned by the Commonwealth Secretariat called A Manual of International Dispute Resolution, which was published in 2007. In common with others of us, he never retired. He completed an arbitration award only shortly before his passing. And he had an infectious enthusiasm for arbitration and a way of bringing people together. And so we thought, and we hope, that this occasion will represent a fitting commemoration of his career. Now, let me say a few words about our guest lecturer this evening, Professor Loukas Mistelis. He was one of the early members of the IDR group. He knew Anthony for many years, and he very kindly accepted instantaneously the invitation to give this lecture. And its title, The Cosmopolitan Arbitrator, whilst having some air of mystery about it, I sense could only be appropriate in the case of the person whose memory we are celebrating. Professor Mistelis holds the Clive M. Schmidhoff Chair of Transnational Commercial Law and Arbitration at Queen Mary, and is the director of the School of International Arbitration. He joined Queen Mary in 1998, became a professor in 2005. His research focuses, as you might imagine, on international arbitration and other things, and he's written and edited and contributed to numerous books and articles. And he has been appointed himself as an arbitrator in numerous international arbitrations and acted as an expert on English and on Greek law in arbitrations. And since March last year, he's been a partner at the well-known firm of solicitors Clyde & Co. So I'm sure we're all very much looking forward to his lecture. He's going to speak, I think, for about 35 minutes, and then he will take questions. So I'm sure you will, in any event, remain wide awake because of the interest of the subject matter. But while you are listening, try to formulate some questions in your mind so that we can have a little bit of a discussion, a little bit of a debate at that stage. Got a roving mic here, which we can use. And then when we've had our questions, James, as I say, will say a few words to conclude the evening, and then there will be drinks and canapes. We hope you will all stay to join us in that final stage of the celebration. So without more from me, I will hand over to Professor Mistelis.
Thank you very much, Stephen. Ladies and gentlemen, it is indeed my honor and pleasure to have been asked to give this lecture in memory of Tony Connerty, who passed away 11 months tomorrow. So my talk will be structured in two parts. In the first part, I will give you some sort of preliminary remarks setting the scene, and the preliminary remarks will cover both Tony, cosmopolitanism, and the current state of international arbitration. And then I will address the central role of arbitrators and the concept of cosmopolitan arbitrator. I've met Tony some 20 years ago. He wasn't my student. He had taken the Queen Mary diploma with Martin Hunter and Julian Liu in the late 1980s, and he was in class with a lot of other distinguished people like Judith Gill, for example. That some of you would know. But then when I joined Queen Mary in 2000, 2001, he met me at the conference, and he approached me because he was trying to find a tribunal secretary or assistant who was fluent in Chinese. Not an easy task, but I'm always rising to the challenge. So I identified a Portuguese student of mine at the time, a PhD student, who was brought up in CAP, who was fluent in Chinese, and they had worked together on a couple of awards, and a few other matters. So when he set up the IDR group, I wasn't one of the early comers, but around 2010, 2011, approached me as to whether I wanted to join, if nothing else because he wanted to bring the average age a bit down. That had been a theme in the IDR group, which of course over the years has engaged a lot of younger people and perhaps got it right towards the end. And of course, the IDR group could have suffered under COVID, but instead of suffering, we had staged a series of webinars with a friend and neighbors of Tony's, who was a computer whiz, and he has sort of changed the platform we were using, and we run a lot of other events. I think everyone who has met him would be, of course, witness his energy and commitment to dispute resolution, and of course, the broader interest he had in international trade, commodities, construction, energy law, law of the sea, pure public international law, and of course, arts and arts business. And it's not surprising that the Times obituary had the headline, Tony Connerty, 83, that was his age. International arbitration lawyer and nightclub owner, not at the same time. It was in 1960. So that came as no surprise. And of course, that also testament to an entrepreneurial skill and an acumen, which was quite noticeable. However, I decided not to focus on the entrepreneurship today. Clearly, something that is needed for a lot of international arbitrators, building up your business, requires a certain skill. But I will focus on cosmopolitanism. And what I always find very intriguing about Connerty is that he was very egalitarian. He was very egalitarian about the cases he had. He would be very excited in a small commodities case or a medium-sized sort of demarriage case. So we did it exactly the same way with the pipelines. So all cases, small or big, were exciting, provided that they had an international element. I think that's perhaps what was the driving force. So when I use the term cosmopolitanism, my working definition is that cosmopolitanism is the idea that all human beings are members of a single community. This should be true for arbitration, the global business, as a global community. And its adherents are known as cosmopolitan or cosmopolite. So cosmopolitanism is both prescriptive and aspirational, believing humans can and should be world citizens in a universal community. So, of course, having had the title, I started looking about cosmopolitanism. Of course, that means cosmopolitan internationalism, universalism, humanism, obviously, globalism. And of course, these days, some of the terms of these terms, internationalism, universalism, humanism, do not attract any critique. But somehow cosmopolitanism does evoke critique. And it seems to a lot of people that cosmopolitanism, and let us set aside the synonymous magazine, has an air of sophistication. And that sophistication seems to be a bit of a white privilege and therefore not an appropriate term to use. So, and I know a lot of that is of course semantic, but I wanted to delve a bit further. And I started by looking at two political philosophers. One is one of my favorites, for people who have attended lectures of mine before, Martha Nussbaum, who has an excellent book called The Cosmopolitan Tradition. And of course, I looked at Jacques Derrida, the late part of his career was also been married, who has a book on cosmopolitanism and forgiveness. So the idea of both books is that the concept of cosmopolitanism comes from Western philosophy. It starts from the Greek cynic philosopher Diogenes, and then that became a rather, in the original term, cosmopolitanism was being forgiving. And Derrida has particularly looked about cosmopolitanism in the context of the global migration trends in the end of the 20th century and the beginning of the 21st century. It's something we even experience now. And he looks at how minorities are being treated, particularly in Europe, when they move across borders. So he says that what underlies the sort of welcoming, the hospitality, as he calls it, hospitalism of foreigners, is ultimately a culture of cosmopolitanism. And we have rights and duties to do with that sort of duty to welcome people. And of course, as you know, a lot of people who have welcomed Ukrainian refugees recently. There has been a lot of movement in the Turkish-Syrian border because of the earthquakes. So that's something that comes up very often and doesn't have necessarily the negative elitist concept, but if one goes back to the roots that Diogenes and to some extent Kikero were discussing has a very particular context. So I would put it to you that sort of Tony in his arbitration work, but also in his personal sort of life and trying to reach out to and support a lot of younger people, embodied very much that cosmopolitanism. And the question is why that seems to be now somehow disjointed from modern arbitration. So if one looks at the current state of arbitration, the picture, at least on the surface, seems to be pretty bleak. We have a lot of negative headlines. People talk about backlash very often. And even sort of reasonably well-informed publications in press like the New York Times, the Frankfurter Allgemeine, or the Monde, and indeed the Guardian, if you can overcome the spelling mistakes in the paper. They are constantly criticizing arbitration. And that's to me quite bizarre because arbitration has been there for long, and I'm trying to understand what is the real origin of that critique. So the negative side of arbitration is this, the negative headlines. The positive side, which has also a negative side, is the expansion of the arbitral subject matter, both in terms of geography and in terms of subject matter. Arbitration was very underdeveloped in countries like Brazil until 2000, and Brazil is one of the largest users of arbitration these days. Earlier in my career, in 2006, I was asked to draft the arbitration law in Cambodia, and I realized that Cambodia never had an arbitration law before 2006. There was some arbitration, but not an arbitration culture or background. So now that we have more and more matters that are referred to arbitration for resolution, this seems to have become an additional point of critique, because the point of criticism is arbitration touching on issues of public interest. And of course, how would one define public interest is a broader question. If you are in Russia, for example, everything that has to do with local financial interest could be a matter of public interest. We've seen on and off, but it's not always the case. And if there's a matter of public interest, the natural reaction is that these matters will be referred to court rather than to arbitration. And of course, there's also the homegrown critique from the UK that the growth of arbitration hindered the development of common law. So a lot of commercial cases, actually the majority of commercial cases, now goes to arbitration rather than to commercial court. And therefore, unless you are involved in arbitration, you're not privy to that development. Another point of discussion was diversity. So often people speak of arbitration as a club, and a club which is primarily male, paid, and stay, but that's no longer true. The ICC has not given yet statistics for 2022, but they said that in 2022 they have appointed 1,000 arbitrators, and about 200 of them had their first appointment in 2022. So 1,000 for a single institution might not qualify as a club, certainly not a very closed club. And the Stockholm Chamber of Commerce Arbitration Institute reported today that in 2022, 54% of the arbitrators that they have appointed were women, and only 46% were men. Again, that gender issue doesn't seem to be cutting there. And there are other numerous initiatives, real, the racial equality in arbitration, the Rising Arbitrators Initiative for younger people, women, which will be celebrating 30th anniversary on the 15th of May here in London. So there's a lot of issues that are being done about diversity, but of course, that's the tip of the iceberg. What about social mobility? We might have arbitrators appointed who are from Egypt, from Nigeria, from Ghana, but very often are graduates of Oxford, Cambridge, or Harvard or Yale, and have trained in big law firms or in major master's chambers. So there is an issue of not diversity, perhaps, but an issue of inclusion. And that seems to be the matter. So if you have had the chance to train with one of the big law firms or big commercial sets, you will find your way somewhere. But of course, we have also broader democratization of arbitration. So we often see, in some cases, somebody who's never acted in international arbitration and then have their first case in front of you. So I think that the final part of this current state of arbitration is what I would describe the recalibration. And in the recalibration, we see, including in this jurisdiction, attempts to adjust or fine-tune the law to make it more attractive. And of course, the side issue of that, the lateral damage of that, is that arbitration gets increasingly highly regulated by hard law, soft law, various layers of soft law, some international law. And I wonder whether the best way for arbitration is go back to the basics and effectively have a pure patent-driven process. So this is a fully developed debate, and I would have spent sort of well more than a few days to describe it. So I won't dwell much on it, but given that arbitration in its modern form can be traced perhaps back to the medieval times and being the procedural part of lex precatoria, modern international law, why is arbitration under critique? In the 19th century, it used to be some sort of an antagonistic relationship with national courts, taking away our work. But is that the argument today? I hear a lot of judges being relieved that the docket has been reduced and all the cases going to arbitration. And in some countries, to give you an example, Slovenia, a few years back, when they introduced both mandatory mediation and arbitration, in a country of about 2 million people, there were 8 million claims in courts. So every person had an average of 4 cases in court. The courts need that sort of privatized entity. And arbitration is that privatized side of the business. So, and I wonder, has arbitration changed? Or has something else that sort of, or have the stakeholders, for example, of arbitration, the use of arbitration, changed their attitude to arbitration? I think it's fair to say that users, ultimate users, corporate counsel, businesses, all they care is about efficiency and cost, and of course, winning as well. And arbitration provides them a level of neutrality, especially in cross-border disputes. So it seems that most of the critique originates from academics and NGOs, and often has an anti-globalization agenda. So it's interesting that Derrida particularly uses cosmopolitanism as a response to this nationalistic populism. And I think arbitration is falling foul of that sort of nationalistic populist movements, and this trend seems to be expanding. Of course, one could name Trump, Brexit, Putin, a lot of Latin American movements. But as I say to my students every day, my toothpaste in the morning is an American brand. I'm sure my toothbrush was made in China, and the tiles of the bathroom were, I think, in Italy, and everything else around. So we are living in a globalized world, so let's not hide behind our finger. But some specific criticism, particularly by academics now, is directed against arbitrators. And arguably, arbitrators have evolved, and more or less that evolution of arbitrators is what has triggered the criticism. Let me elaborate on that. So, if we look at the 20th century, which is in some respects the golden era of arbitration, the time when the adoption of the New York Convention, arbitral awards are easily sort of circulating, and perhaps we see some of the end of that golden era at the beginning of this century. The very big arbitrator names, whether it was Dick Clyde, Cedric Barclay, or whether it is sort of Pierre Lalive, Smithoff even, they would have done in the career about 20, 30, 40, 50 cases. We have a lot of arbitrators now, only do arbitration. I have done perhaps 100 cases already. There are people who are only doing arbitration and not have another job. I have another 2 jobs. I might have done even more cases than that. And so arbitration has become sort of a full-time profession. And in that respect, stakeholders have started developing sort of their own thinking about arbitral appointments. So categorize arbitrators in groups, work for insurance, work for contractors, work for employers. And it seems that almost everyone seems to be falling in a camp. So all of the other stakeholders now have raised the game, and they have a much more intense scrutiny of the arbitral work. If an arbitrator does a few type of cases, that's not matter for. And I would think that arbitrators is the source of legitimacy of arbitration, the arbitration process. So the arbitration is as good as the arbitrator, because in every single case, one party would lose. It's impossible for both parties to win. But the question is, how you explain to the party that lost why they have lost, and how do you explain in the way that they are agreeing with you? And I remember when I was talking to Tony a few years back, one of the points that was coming is that you always write your votes for the losing party. The winning party goes to the final page and see how much money they get out of their work. But the other party needs to understand why the thought process is what it is. And if you try to convince them, that's the legitimacy of the process. Of course, the legitimacy of the process is also that the arbitrators are being appointed by the parties. So arbitrators became a point of criticism because I would think that in some matters, some of the sort of the ontology of arbitrators became a bit more relaxed. Another friend would say that arbitrators, what they have to do is to show a bit of leg, quote the price, and say that they're available. And very few people say no to appointments. So one of the classical problems of arbitration is repeat appointments. So we know we have ethical rules which suggest no more than 3 cases from one party in a period of a few years. But if you hear stories which doesn't sort of add up, and of course, a recent English case is addressed that particular concerning repeat appointments and disclosure or non-disclosure as a key point. So arbitrators are effectively service providers. And as service providers, the quality of the service is critical. Any deterioration, would create sort of the wrong type of competition. So it's important to keep arbitration in that level, what I will often call as and we'll discuss about that, as a luxury market. So in this luxury market, we don't compromise quality. But of course, arbitrators are also private judges. I mean, if you look at American court jurisprudence, consistently since the 1800s, they equate arbitrators to judges and are afforded to arbitrators exactly the same privileges as judges. Of course, England is not far apart at all from in that thinking, but there's some sort of a qualified immunity in the English Arbitration Act. If you move, however, to other countries, I will mention Austria and Finland, perhaps the whole Nordic states, there's no arbitral immunity. Arbitrator is subject to liability like any other service provider. And so they don't have that elevated status. I think the elevated status in Europe, on the continent, was effectively guaranteed for the so-called power net. People have done a few cases because of their reputation. No one ever talked about how much money people take. They trusted their judgment because they trusted the passion in the community to make the decision. So, but arbitrators becoming professionals is what I would call the case of independent arbitrator. You must have seen them. If the card says independent arbitrator, that means full-time arbitrator. All arbitrators are independent, by definition. If not, they're not doing their job. But some of them who only rely on the business, therefore dependent on income, are called independent arbitrators. And I think that this screams for more regulation. Is exactly what they wanted to avoid, but they fall into a trap which they create themselves. So where we are and why Cosmopolitanism? Arbitration is a luxury market. You arrive at Heathrow and you can take the tube to come to central London. It's not comfortable, it's not clean, but you're going to get there and it costs you £5 or £6 to take it for some time. That's the court system. You can take a taxi, blackout, not cheap, but again predictable. We subjected to discussion we don't want to have about the weather and Brexit. It's the Windsor framework. But it's reasonably predictable, and that's what we call institutional arbitration, the ICC type of cases. Of course, as an alternative to the institutional arbitration, from 6 to 60 or 70 pounds, you have variation, you have UB, you have local mini-cap contracts. That's all of the other smaller institutions that provide exactly the same service. And of course, you can have your limousine, you can have a helicopter, you can go to farm communications. That's ad hoc arbitration. So There you procure everything yourself. Nothing is guaranteed. It's as much you're prepared to do, how much you're prepared, that's what you get. But arbitration is not luxury market. So if you're that luxury market, you don't compromise in terms of quality, you don't compromise in terms of fees. Because if you are that brand, you're not never going to charge too little. But some of these independent arbitration markets start creating a bit of a competition in prices, arbitrage, which seems to be a bit sort of a matter of concern, because arbitration, as well as being a luxury market, is a global market. There are black ops everywhere in the world, and there are helicopters everywhere in the world. So in this global market, how do you access? And for some people, one of the ways to access is to drop the prices. And I have to say that when you start out, the challenge you have is you cannot have the infrastructure to be arbitrated. You don't have a backup, you don't have arbitral assistance. Because at the beginning of the cases, we just accumulate sort of the capacity to do the work until you get to the right level, in which case you should be very, very busy, by which time you can have sort of the proper infrastructure to support it. It's also, and that's the other important aspect of cosmopolitanism, a very culturally sensitive market. We talked about only in China, Nigeria, in other parts of the world. And it's not only where you go for your hearings, but you have to make sure that the disputing parties, and most importantly, the lawyers, have trust in you. If the lawyers have trust in you, the parties eventually have trust in you. But you have to instill that trust. And that's an argument perhaps against diversity. The older you are, or the more experienced you appear to be, the more trust the parties will have in human rights. It's not a good argument for diversity, but that's the reality. It's human nature. Of course, I've seen a lot of people standing up to sort of raising the occasion and behaving in a particular way, and they very much sort of reflect that authority when they become chairs. But I think arbitration would lack legitimacy if in an entirely African case you have 3 white men in arbitrators, or in an entirely sort of Asian case you have sort of people who have nothing to do with culture. So we have to be aware of that, and we have to be able to say no more often in this type of point. Of course, the other interesting aspect about this sort of cosmopolitan sort of market is that it's regulated partly by contract and partly by law. The contract is perhaps best exemplified when you have an institutional arbitration where everyone contracts with the ICC, and the ICC collects the money and circulates them at the end of the story. When you have an ad hoc arbitration where you technically do have a contract with the parties because you have your terms of appointment, that can become very complicated. Because depending again on culture, parties start negotiating their terms, negotiating. So at the very start of the case, there's a bit of a sort of a Turkish bazaar almost atmosphere until you overcome it, and the terms have been established with the case. Whenever I'm in ad hoc arbitration, I will always use a fund holder and get sort of that sort of coverage that I need, because that's very critical. And of course, the final part of this is the question of the immunity or liability. We've seen from moving from the US to Northern Europe, there's a lot of different stages of what can happen. And of course, it's not many years ago that we had a couple of colleagues, in particular in the Gulf region, in Dubai and Qatar, under criminal prosecution for decisions they have made against the state. Of course, this has been resolved, but there was a period of uncertainty. So immunity or liability is part of that sort of global market and how that is regulated. So is there a particular sort of species of cosmopolitan arbitrator? Obviously, somebody who is culturally sensitive, somebody who is outgoing, somebody who is sympathetic and forgiving to the cultural sort of attitudes of other people. That all comes into the picture. I have seen a number of very well-known arbitrators being completely unsympathetic to culture and not being able to even sort of get outside their own legal system. So I was sitting a few years ago with a former court of appeal judge as a chair in a case which was governed by Greek law and Italian law. All the conduct was Greek law, parts of a particular clause of the conduct which was Italian law. He could not get out of the English law context, the reflective. What's your best authority? It doesn't really matter. In Greek law, you look at the statute, you look at the comment. And as somebody who is getting a lot of appointments, but of course has the authority, has a very good decision-making capacity, working with facts very well. Is he cosmopolitan? I doubt it. And certainly also has issues about diversity and so on. So what makes arbitration cosmopolitan is that the arbitrators have to bring them to the picture, or is the arbitration by design as a neutral cross-border business dispute resolution system, what is cosmopolitan? I think it's a bit of a chicken and egg situation. I think arbitration calls for cosmopolitan arbitrators, and cosmopolitan arbitrators promote arbitration in the right way. When the two collide is amazing, because you have an exercise in sort of comparative law and sort of a cross-cultural context, and that works incredibly well. But the question is professionalization a challenge for the moment? Because being cosmopolitan in this sort of Derrida, the organic sense, means that you take the extra time to engage with the parties, to engage with the file, to understand the culture, rather than have the tribunal secretary who is starting drafting the vote as soon as you start the case. And you only prepare for the hearing. That means you are a very good proceduralist, you know how to run the process, but you have disengaged with the parties. And arbitration as a personal service, it's critical that you engage with the parties. So of course, less is more. Again, the point about repeat appointments, it is critical in my view that one takes time it takes to engage. So again, there's a lot of anecdotes that one could bring up. So, for example, in Russia and the CIS countries, people negotiate a contract, then have a very extensive meeting, they get drunk, and then they sign the contract. From an English law perspective, none of these parties have capacity to sign the contract. But the contract has been agreed well before the launch. So it depends on sort of what is your cultural context of whether this contract is valid. Because some people will be sympathetic to the objection that this contract should not be valid. But it is, because that's the way business is being done. Or of course, there are a lot of different similar examples that this can bring from different contexts. So I think the challenge at the juncture where we are, starting from sort of the negative story of the criticism and the backlash, is that arbitration can be saved only by arbitrators at this stage, not by regulators. And either we have restraint, self-restraint, or the alternative is regulation. And that's kind of so I think it's critical to exercise that restraint and to continue to be cosmopolitan. So thank you very much.
Thank you very much, Loukas. Now, my colleague Amy is going to hold the mic, and shall I let you sort of moderate the question? Would that be a good idea?
Well, the ones I don't think there's cosmopolitans in this place, but
Hi, good evening. You mentioned during your lecture about how populist nationalists had affected arbitration or in particular to Russia. Could you give us an example, expand on that?
That's actually an easy question. I mean, I've been obviously it's inevitable to think about Russia at this stage. And this particular jurisdiction has been criticized for having opened the doors to receive money from Russia for years. And some of the response in the last couple of years, but also in the last year with sanctions, seems to be some sort of a moral remorse. It's called. In Russia, this nationalist populism, particularly under Putin, has had two illustrations. I think in 2012, 2013, there was a law that passed that was referred to as repatriation of Russian disputes. The law was eventually repealed. I think as everyone who practices in this jurisdiction knows that in the High Court, some of the most common litigants are Russian, Ukrainians, Kazakhs. And I think it's fair to say that even in the LCA, about 1/3 of the cases have the CIS. So a lot of these cases are sale purchase agreements in Russian companies, Russian controlled companies, which might be incorporated in Cyprus, BVI, almost rarely in Russia, but having ultimate beneficial owners in Russia. So the the war against the oligarchs started in Russia. So the repatriation of Russian disputes was part of this nationalistic populism. People have taken the wealth from this country, and they sort of became a playground. London style, as it was often referred to. Of course, now in the sanctions, there is a recent Russian law which suggests that every matter that has to do with the sanctioned party is an exclusive jurisdiction of Russian courts. And then over the years, we have seen other attempts. We've seen an attempt by the Russian Supreme Commercial Court, confusing this called Supreme Arbitration Court, that inter-corporate disputes are not arbitrary. They have to be resolved by courts in Russia. Again, that of course was repealed. I mean, there are a lot of these movements because there's been a lot of lobbying. But obviously the oligarchs lobbying seems to be carrying off quite a bit. And it was very interesting. I don't know whether you have seen, I mean, because of the tip of the iceberg, Russia, there's this sort of documentary called Citizen Kane, which indicates that everything is complicated there. But one of the points of irony is that oligarchs want the only sort of hope for democracy in Russia. And if that's the case, it's very sad. So there are these three sort of attempts, the three acts, the repatriation of Russian disputes, the banning of arbitration of inter-corporate disputes with Russian parties, Russian residents, and now, of course, the sanctions, which contain every dispute. Russian is Thank
you. Anthony Connerty wrote an article about dispute repatriation. Says at the end of the article, spoken adjudication that we just touched. I wondered whether you could talk to us about whether you consider adjudication as art to be a way forward, and also is adjudication more cosmopolitan than arbitration? By your terms of reference.
Yes, of course. I think my disclaimer first. I personally have not been with adjudication. I've seen adjudication in the construction industry context. Now, when it comes to art disputes, and with my sort of birth nationality of Greece, which talks about the very time of the Parthenon martyrs and the various projects that exist there, and the various projects that are underway in the UK and in other parts of the world. I think adjudication has there are a couple of areas where I can see adjudication meaningfully growing. One is arts, because it's better to have that level of resolution an entirely private, in a private context like that. And also because I think adjudication entails that experts will be involved in the adjudication, particularly process, and then you bypass the technicalities of the case. Another area where I think adjudication will have quite a bit of, and seems to be getting involved, is in an energy transition, particularly nuclear. But I don't, I think adjudication requires a particular culture, and this country possesses, but I think a lot of civil jurisdictions require a higher degree of flexibility than the adjudication. So, I've been in cases where contracts provide for adjudication before anything else. And lawyers argue that, especially continental lawyers, Germans, Italians, that's not part of our culture. It's just that if adjudication has a scope for success, but that's not scope. But of course, the UK experience.
You talked about cultural sensitivity. I have cases at the moment, a lot of arbitrations in the High Court in which the witnesses are all Thai, and it's a fraud claim. So the question of backdating of documents is very significant. The English lawyers take the view that backdating documents is evidence of fraud. Thai witnesses take the view that backdating documents is just something that happens to them, and with most evidence attached to it. So I wondered how Cosmopolitan Arbitrator.
Very concrete question. I think as it will really depend on whether the arbitration is a time or is a cross-border matter. Because if it's a cross-border matter, you don't take the culture of one party in the picture. But you might sort of accept a slightly different view if it's an Italian domestic case. Of course, I think the ethical duties of an English lawyer is what it is, and I think you cannot disregard that this is a forged document, for lack of the word, and perhaps use backdating. It's more polite way of putting it. And I have seen it, and I had a cross-border arbitration where one of the lawyers argued that he had seen the original document some time ago, and the original document was different. So what we did to deal with that cultural issue is that we appointed, we had somebody, a technical expert, to see whether the computer data was manipulated to tackle something to control the CPU. And the second thing we did is that the seat of the arbitration was in Stockholm. So we started the arbitration on a Sunday afternoon, just to formally open the arbitration. And the following day, we moved to the Court of First Instance in Stockholm. The judge opened the case on our matters, and then he stepped aside, and the arbitrators went to the bench as arbitrators. The judge in the background, in case there was a matter that actually had to be taken. And so the party sent it a week before the hearing. So there are ways of dealing with that.
You raised, interestingly, the statistics from the ICC on the numbers of different arbitrators appointed, and a very large number, 200 odd first-time appointments in the ICC. The LCIA, for its 2021 report, was very proud to announce that similarly, it had seen a larger number of arbitrators being appointed, more first-time appointments. And it was a very small percentage, maybe fewer than 10%, who'd taken more than 2 appointments during the year. So my question is, when you're looking at the professionalization of arbitration, there could be a perception that the institutions are quite pleased to see, if you like, a backwards evolution towards more amateur arbitrators. That is to say, arbitrators who, if they are doing institutional arbitration, are of necessity going to have another source of income because they're only going to get 1 or 2 appointments a year in the institutions. I wondered what you thought about the way the market is evolving in that sense. Will some of the independent arbitrators who specialize in institutional arbitration survive with this kind of structure in place? Or can they hope that actually arbitration internationally is going to expand and that the cake will grow?
I have 2 responses I can say in public and one I will say privately. What I can say in public is that I think the direction of travel is such that the role of independent arbitrator is not viable. Especially the independent arbitrator who is not retired from that job, or is not a person of independent right, person who is scholar. Because I think there will be a lot of the appointments will be outside the radar of the institutions, which is friends and friends we have confidence with, have sat with before. But if institutions are true to their word, they will be blocking a lot of these appointments. Of course, if one looks at X, all the data is public. It's evident that some people are serious big players. People might have 10 or 12 or 15 points at a time. I don't think the ICC or the LCA would be prepared to do that. But it would be interesting if there was a different way, a more objective way, and I know you're sensitive to that as I am, if there was a sensitive way of providing data, not only how many cases registered, but how many cases go to a hearing, and how many cases go to an award. Because you see a number of thousands. So, and if you talk to people and you trust the judgment, you realize that they're busy, but not as busy as we say we are. So there's a bit of a disjoint there if you get data from people and you get data from institutions. And I think there's some dots missing, and I think we don't have that picture. But if one were to move towards diversity, and of course, if one were to very, very similar, a lot of the ICC first appointments are former ICC counsel well in the practice. There's even an ICC alumni group, it's interesting to see how many of these alumni group are being appointed. So I'll say it doesn't have that practices, you know, and other institutions don't. But if one were to look at diversity, that it would not be possible to sustain 200 or 300 independent arbitrators within the district.
Thanks very much, Lucas. It was interesting to hear that your views on to what extent you think lack of cultural sensitivity has driven the growth of arbitration in other corners of the world, whether you think other factors are significant in that growth.
I think there are 2 possible answers to that. Modern arbitration is effectively a global Anglo-Swiss export. So you have the English arbitration export and the Swiss arbitration. I know I should say French, because a lot of the original French was driven by the Swiss way of thinking. So and that, even with the lack of cultural sensitivity, had an element of authority, because so one would almost sort of look up to this very experienced English judge, you know, he's an arbitrator, or this famous professor from Paris, from France or Switzerland, who has a lot of authority. So that has driven a lot of the reform, has driven a lot of the growth. I think Latin America in particular is very much more than this Franco-Swiss arbitration until they found their own way of doing it to some extent. But all of the growth is on that basis. And the Commonwealth Asia is more than after the English system. And I think you will find a lot of people in Asia, Southeast Asia, where they think that they're benefiting from this English law experts. So the exploitation of English law in English country was very positive. I mean, that's certainly the case in Hong Kong, and still is, in Singapore, and all of these other offshore jurisdictions, Kazakhstan, Dubai, Qatar, and so on. But I think as the local market grows, and it grows, you see that some of this sort of work comes from London to Australia, for example. There's now a number of Chinese lawyers qualified here and take up that work because they can profess themselves both in common law and the local culture. I see that transition happen, and I think it planted sort of the seeds, but now that it's growing, one should sort of accept that some of this money will stay local, regional.
Thank you very much for your very interesting talk. Tony Connerty was not only an arbitrator, but also a mediator. Is it your experience that the spread of mediation is having any effect on the appetite of international parties for arbitration?
Again, culture has quite a bit of role in that. I did all my basic training in Europe, not in England. And when I was doing training in Germany, for example, in the 1990s, all mediation was either family mediation or criminal mediation. So the victim of offenders, so mediation was very, very common. Business mediation started growing after mediation grew in the UK. And of course, the UK has grown business mediation, commercial mediation first, and followed by the Netherlands quite quickly after that. But other European countries were much, much slower. For example, Germany, Italy, of course, moved to a system of mandatory mediation. And Asia has this hybrid art-bed sort of using mediation techniques in arbitration. And so, and even look at Scandinavia, for example, mediation is not as big as one because people want certainty, so it's either court or arbitration because we know one or the other. And Latin America seems to have that sort of swing. Now, in the US, of course, mediation is there. I mean, there are thousands of cases of mediation. And again, if one reads the CEDAR sort of audit every year, the numbers in this country look very, very high. Now, I think part of the problem for mediation is lawyers. If mediation works, we will have less work, much less work. But there have been cases where I have advised as a counsel, advised parties to engage in mediation, and they wouldn't, because they would rather have an authoritative enforceable award or court judgment, no matter how much it takes and what it costs. And of course, you know that that's a disaster waiting to happen. And once they've gone through a bad experience, then second or third time they could possibly engage. But it's a slower process, and I think there are a lot of parts of the world where mediation is really under development. Many parts. And almost everything that mediation, because it's entirely in the private sphere, it requires a very mature economy and a very mature culture where people trust private as well as the trust state authority. So the more people are heavily reliant on the state, the less likely mediation is to no.
I'm tantalized by the slide that we've been looking at for the last 20 minutes anyway. And I assume that is the cover of a book by Martha Nussbaum entitled The Cosmopolitan Tradition.
Yes.
Could you say a little more about what she is referring to in mentioning the cosmopolitan tradition, and expand a little bit on what you were saying about what's the cost of human arbitration.
Yeah, I mean, Martha Nussbaum is a legal philosopher with the University of Chicago. And she has a number of very nice covers and very nice titles. I mean, my first book I read of hers was called The Fragility of Goodness. Like a very good novel, but it's not. So her theory is that cosmopolitanism is in essence political tradition, political thought. And she takes the view that cosmopolitanism is focused on the human person rather than on social class, gender, lineage. And it says that the origin of cosmopolitanism, the Greek Stoic philosophy, was human-based. And it was very egalitarian. That's why he uses the word egalitarian. And so you're cosmopolitan if you think that everyone should be treated the same way, or if all human beings are equal well. So that's, in her view, this sort of original sort of thinking behind cosmopolitanism. Of course, she says, and as you see, a noble but flawed idea. And actually, this book is a collection of talks she has given. And then she says that this vision of world citizenship is best exemplified first, of course, in the Greek and Roman antiquity, but then in modern terms by Hugo Grotius. Hugo Grotius was one of the founders of modern international law, and also one of the founders of modern arbitration in some respects. So her view is that the original cosmopolitanism is exemplified by Grotius, and is also somehow debated adequately by Adam Smith in the 18th century to this island. So she thinks that there's a number of tensions. The point I made that we live in pluralistic societies, and for some reason, cosmopolitanism has lost its original meaning and being a bit more elitist. I mean, I used to joke in my class that people who were successful in arbitration in the golden era are people who were cosmopolitan, which means they spoke French, or they spent a year abroad. So of course, that doesn't mean anything these days. I mean, if you really go to the cosmopolitan, you have to spend a bit of time in India and Japan, Africa, join the Peace Corps, some of that. So I think the concept of cosmopolitanism has evolved as mathematics. Back to the basics, if one looks at the basic ideologies view of cosmopolitanism, that's what the question is.
Thank you very much indeed, Lucas. Good evening, everyone. For those who don't know me, my name is James Clancy, and I'm an arbitrator, an independent arbitrator. Or, as I prefer to say, but it's a bit more long-winded, an arbitrator in independent practice, because as Lucas correctly said, all arbitrators are independent. And I'm fortunate to be an associate member of Six Pump Court Chambers. And indeed, it was Tony who introduced me to Chambers, which is something for which I shall always be grateful to him. And it falls on me to thank Lucas for his fascinating lecture, which suits this occasion perfectly. It dealt with a subject which Tony and the IDL group, I like to think, tried to live. And at the same time, it was topical, addressing issues which concern the international arbitration community at this point in its evolution. And as an arbitrator in independent practice, much of what you said certainly resonated with me. Tony Connerty was a real adventurer in international arbitration. He was always keen to learn about new kinds of disputes, procedures and rules which could help to resolve them, and about the different ways in which things were done around the world, and in different business sectors. And it was with that spirit and with that talent that he had for bringing people together that he founded the IDR group some 15 years ago. By its very nature, the IDR group's membership was spread around the globe, and we invited as many of its members as we could to this event, which is the IDR group's last hurrah. But only a select few of us have been able to make it this evening. And I would note in particular, we have John Canterbury sitting quietly at the back. And we have Peter Foreman, former treasurer and honorary secretary of the group with us this evening. But I would like to say a few words about some who haven't been able to make it. In particular, Sarah Eski-Yorok, Professor Sarah Eski-Yorok, is extremely sorry not to have made it. He was intending to come. But he is from Adana in Turkey, which has been badly hit by the earthquake. And he, although he and his family are safe, he simply couldn't leave. And he was a stalwart of the IDR group. And indeed, I was privileged to meet him when the IDR group, Tony in particular, organized a fantastic conference in Istanbul, which in some ways was the germination for what is now Istanbul Arbitration Week. And I met Sarah there in 2017, and the following year, there was a delegation from CPAC who came to London, and they wanted to see Tony, they wanted to see the IDR group. And we had a meeting with them in the old IDRC building I used to work in when I worked at the LCIA, Fleet Street. And it so happened that Sarah was in town and he came along as well. And that's just an example of the kind of thing that Tony used to organize. The Chinese delegation, I think, were expecting to meet only some British arbitration people in London, and they were introduced to a young Turkish professor. And that's exactly how in international arbitration, the networks that it creates and that it lives on, that's exactly how they should proceed. Near home, we're missing this evening Arthur Harvard, who was one of the original founders of the group, and from whom I took over as treasurer. He sent gracious apologies in his usual way. And I would also like to mention a recent addition to the group, who was mentioned by Loukas earlier, and that is Ed Murphy, who is a friend of the family and a neighbour in St Leonard's. And he was a whiz at IT and managed to set up a completely new website for the IDR group in the middle of the COVID crisis. And we had, as Loukas mentioned, a short series of successful webinars. Again, Ed's not been able to come this evening, but we are in the IDR group very grateful for his efforts. And I'm also delighted to see that some students from Queen Mary have come, and I say that because I know that Tony would have been excited as well, because introducing young people to arbitration meant such a lot to him. I would also just like now to extend thanks to Six Pump Court on behalf of the IDR group for collaborating in organising this event, and for helping to put it together. And so I'd like to thank my colleagues in Chambers, and particularly to Bridget Tuff, who is actually sitting in Chambers now, remotely dealing with the recording. Everyone has been very helpful in getting this together. Tony would also have been delighted that quite apart from the lecture, we are going to have some drinks and meals and have the chance to mingle. And that's what we shall do next. But just before we're doing so, and everyone is welcome please to join us now. Could we give one final round of applause to Loukas for his great lecture?
To 8. Oh, okay. I thought it was